Okay, right. I think we will get going, and then people can join us as they come along. Should be good. Okay, so I'm just going to share my screen. So hopefully you can all see that now with a lovely picture. The only construction related picture I could find that was vaguely interesting. So as it says, my name's Simon. My name's Simon Franklin. I'm a director in the construction team here at House Percival. And I'm talking to you this lunchtime just to give you an introduction to construction documentation, a little bit about what it is, what it does, what we do as construction lawyers, and why it's needed, and how it relates to what you do. And hopefully there'll be some interesting things might click into place and make sense when you've heard various people like me talk about various things. You might suddenly think, ah, I know what that is now. I understand why they're banging on about those warranties or whatever. So we'll start off by, this is roughly what we're going to be talking about. So a bit of introduction to procurement, what we mean by construction, how it sort of works, to give you a bit of an idea of how these documents and documentation work together. We'll touch briefly on building contracts, what they are, the key terms of the building contracts, and then appointments. So the similar thing with professional appointments for architects, engineers, etc. We'll talk about collateral warranties, which I mentioned previously, and take up a lot of time and seem to cause a lot of confusion. But touch briefly on letters of alliance, what they are, when they're used. Then on to latent defects warranties, again, a topic that comes up quite often and perhaps slightly misunderstood. And then finally, we'll round off with just a brief mention of performance bonds and what they are and how they're used, and again, try and clear up a little bit of misunderstanding about what they are. We've left time for questions at the end. I think that's probably easier because sometimes you'll ask a question and actually on the next slide it's answered. But happy to answer anything at the end. Anything you're not clear about, you need clarification on, not a problem. Just give me a shout. So if we start, so when we talk about building contract, when we talk about procurement, we talk about there's a couple of different options. So what we've got here is originally this is what's called the traditional procurement route. This was the way that it's always been done up until relatively recently. So what you would have is this structure we've got on the screen here. So you have a client, they engage the contractor, they engage separately the design team, the architect, the engineer, and everybody else. And then obviously the contractor in turn will engage numerous subcontractors. There's probably 6 or 7 of these across here to actually carry out the works in relation to all the specific packages of works that they would do. So what we have is the employer directly engages the design team to complete the design. So what we do is it's a bit of a two-stage process. So the employer will start off, talk to the architect, talk to the engineer, get the plans, get the drawings, specification, all prepared, all priced up, ready to go. They will then take that to tender, give that to the building contractors, and the successful tendering contractor is then engaged to build in accordance with that design that was prepared by the design team. So the idea is that you've got a separation of design and workmanship liability. So any issues with the project that relate to the design, it sits with the design team, sits with the architect and engineer. The contractor is not responsible for that. The contractor is only responsible for any problems he's got in implementing that design. If the workmanship's poor or he doesn't follow the plans, etc. So because the contractor doesn't have any responsibility for the design, generally under this traditional procurement route, he doesn't need to have any professional indemnity insurance to cover him against professional negligence in relation to that design work. That's strictly speaking the case, but like as most things, especially when you get lawyers involved, it's a little bit more complicated. There are traditional forms of contract that allow for a degree of contractor's design. It depends. Sometimes you have you're building a hospital and you've got a contractor who's built hundreds of them and has got an expertise in designing the requirements of the operating theatres, etc. So you might, as a client, if it's the first time you're building a hospital, for example, you might pass that on to the contractor and say, okay, you can design that part. But traditionally, under this form of procurement, you have design responsibility sitting one side and workmanship sitting the other. Now that's got a couple of advantages. The main ones are on the screen here. It's greater cost certainty. So it means that you know you've got the building designed, you've got it all spec'd. You should at this before you go out to tender, you should know exactly what the project's going to cost you, or should cost you, subject to obviously late subsequent changes and things like that. You've also got more control over that design, obviously, because you've got greater input in terms of getting the architect and the engineer involved up front. You can get it, you can finesse it, you can make sure it's exactly what you want before you take it out to contract for tendering purposes. The disadvantages is that sometimes obviously that process can take quite a long time. There's no overlap between design and construction. You've got to get it already spec priced before you take it out to the contractor market. So it can cause a longer lead-in time for projects. And the other one is also the greater litigation risk. This is obviously from a lawyer's legal perspective. If you've got if you've got a contractor who's responsible for the workmanship and you've got a design team who are responsible for the design, if there's a problem, most cases it could be a combination of both of those. It could be a bad design that's caused a problem, but then the contractor hasn't implemented it as well. So there's sort of no one person you can go to and go, look, I've got a problem with the building, you need to sort it out. You might end up having to sue, bring claims against 3 or 4 or 5 different people in order to recover your losses. So you're looking at obviously increased cost, increased time, and the risk that some of those parties just may not be around anymore. The insolvency hit rate in construction is incredibly high, so you've got greater litigation risk this way. So that's the traditional way of how projects have always done, and some are still done, are still procured and managed this way. The alternative of what's become much more popular in recent years is what's called the design and build procurement route, which for those of you like me who are old enough to remember the Ronseal adverts, it does what it says on the tin. So you have a client, they engage the contractor, and then the contractor who's responsible for engaging both the subcontractors, as before, and also the design team. They take on the design team. They will either appoint their own or they will take an ovation of the client's design team. But the idea is that, unlike traditional, there's no contractual separation between design and workmanship. The contractor takes responsibility for both. So any problems, whether it's design or workmanship, your first port of call is the contractor. As a result of that, they're going to need PI insurance. As I said, the design team is either appointed directly by the contractor or is novated from the client over to the contractor if the client's engaged early on with the architect to get some initial design work done, for example. Or sometimes quite often you'll have a mixture of both. Because the client now no longer has direct engagement with the design team, because it's now sitting with the contractor. In these instances, the clients will quite often request collateral warranties from that design team to give them protection in the event that there's a problem with those designs. But we'll touch on that in a bit more detail in a moment. So in terms of design and build, I mean, the advantages and disadvantages are pretty much the opposite of the advantages and disadvantages for traditional. So it allows you to start on site early because you can get the contractor on board early before you've got a fully spec'd up design. There's that more of an overlap between design and build. So it allows projects to start more quickly. It also, as I mentioned, you've got a single point of design responsibility. The idea is that any issues with the project, your first point of call, the buck initially stops with the contractor. So you don't have that litigation risk of having to sue 4 or 5 different people, potentially. The disadvantages, projects under design and build tend to come out at a higher cost than traditional procurement, simply because the contractor is having to factor in that design risk to his contract sum. He's taking on that extra responsibility for the design, therefore he's going to price that into his contract. And you also have less control over the design. It's not that you hand everything over to the contractor. You still have input and you still have say, but it's less of a, this is, here you go, Mr. Contractor, this is what we want. It's, here we go, the contractor, this is kind of what, how can you input into this? And that if you need something really, really bespoke, perhaps design and build isn't the best way to go. But most projects now, 90% of the projects I deal with at the moment are on a design and build basis, just because it's that the advantage of that single point design responsibility, getting on site quicker. That seems to people seem to favour that over the more traditional procurement route. The other one I want to touch on briefly, which is quite relevant for you guys as well, is there also obviously there's term maintenance contracts, which are used for obviously maintenance repairs. Where you need to engage a contractor. You don't necessarily need him to do a specific job, but you need him on board, ready to respond should the your housing stock need painting, or should the gardens need maintenance and things like that. So rather than going through the process of engaging them under a new contract every single time, what you will do is you will have an overarching contract which has all of the main terms and conditions, all requirements in terms of insurance and work obligations, and then you will have an order form or a called off contract underneath that. And each time you want to instruct a piece of work, you just issue that, and that's governed by the overarching contract, that whole terms. The terms of a term maintenance are very similar to a construction contract. It's just that it sort of, it separates that call off period, and signing the initial overarching contract doesn't necessarily commit you to any work, only when you then subsequently issue the call off order. So they're the main procurement options. There are others, but they're very rarely used, and they get quite complicated and probably beyond the scope of this talk for now. So in terms of building contracts, the most common form on the market in the UK by a long way is what's called the JCT, Joint Contracts Tribunal. It's actually a suite of contracts for a range of size and complexity of projects, anything from works in a domestic house, extensions, etc., to multi-million-pound multi-use commercial developments. They cover all broad range of spectrum. They have both design and build and traditional forms. They are what a layperson would look at and think of as a contract. It's very prescriptive. It's very, this clause refers to this clause and this happens and subject to this, etc. So it can be quite difficult for a newcomer to a contract to penetrate and work out how it functions and how it operates. But it's very clear. Lawyers, it depends. I like them because it's quite clear and it's quite easy to follow once you know your way around. But they are quite bulky and they can be quite intimidating. NEC, new engineering contracts. So again, they're an alternative to JCTs. They're written much more, I suppose, not being disparaging, but from a layperson's point of view, they're much easier to understand. The language is much plainer, much simpler. It's stripped out. There's very little cross-referencing to clauses, etc. They tend to be used more in a public procurement environment. I've certainly come across them when I've been in public work rather than private work. They were generally drafted. The idea behind them was they were slightly more collaborative than a JCT. So the idea was that everybody would work together, rather than the contract saying this is what happens, this is what happens, this is what happens. The NEC is okay, well, in the event that this happens, you talk and you decide how that's managed or how that risk is dealt with. So from that sense, they're much more collaborative and involving, but it does mean that as a client engaging under an NEC, you need to have a lot more involvement, and you need to realise sort of upfront that you need to put the work in to get the procedures in place to make the contract work. Whereas a JCT, you can take it off the shelf and it will work. You don't need to do anything. So it swings and roundabouts what people prefer. Some people like the NEC, some people prefer JCT. It's what you're used to and how much involvement you want in it, really. There are others, but these are the main two in the marketplace. So coming to building contracts generally, obviously there's lots of terms and provisions in there dealing with all kinds of things, but generally speaking, it can be boiled down to the contractor's obligations under a building contract are as on the screen. So their obligations to carry out, and if need to be, design the works in accordance with good building practice, good quality materials, in accordance with the contract documents. So that's the specification, the drawings, etc., etc. There's an obligation to comply with statutory requirements, so planning requirements, building regulations, etc., Building Safety Act now, etc., etc. Obligation to complete the works by agreed completion date, subject to EOTs, extension of time, which we will come to, and an obligation to maintain all the required insurances. There's other provisions in there, but effectively that's the contractor's obligations in terms of the works. So when it comes to completion, so as you said, the contractor has an obligation to complete the works by a stated date for completion. Failure to meet this can leave the contractor at risk of what we call liquidated and ascertained damages. You may have come across them. They're called LADs, liquidated damages, LADs, numerous words, but it's essentially it's damages for late delivery of the works. If the works are late, you pay these damages. And the idea is that rather than the employer having to prove what damages he's suffered and mitigate and go through all that process of establishing what the costs are, a figure is agreed up front and included in the contract. Now it's expressed as a fixed amount, not either per week, per day, sometimes monthly, but generally not. Generally, it's weeks per week or day. And that figure is what's called a genuine pre-estimate of the loss. So it's okay, if this project is late by a week, we are going to have to pay X, or we are going to suffer X. It might be, loss of rent. It could be extra financing costs. It could be, any penalties from local authorities or something for not providing any loss that you will suffer for that project being late. The idea is that you then look at that, aggregate it all together, and say, okay, if you're late, it's going to cost me £5,000 a week, and that figure gets put into the contract. It has advantages for both sides. Obviously, you don't actually have to have suffered that loss to claim it. So if you're saying that LADs are £5,000 a week, if they're a week late, the contractor is liable to pay £5,000. You don't have to prove that you've lost that £5,000. You don't even have to have lost that £5,000, but he is liable to pay it. So from the employer's point of view, you know that for every week you're going to get £5,000, and you don't have to go through any process of proving it or establishing it. From the contractor's point of view, it gives him certainty as to what his exposure is in terms of his liability. So he knows that, okay, if I'm a week late, I'm on the hook for £5,000. It's not a case of I'm on a week late. Oh God, I could be paying £5,000. I could be paying £5 million. I could be paying £5. So the idea is that it's an advantage for both parties in terms of and as long as it's a genuine pre-estimate, and it doesn't have to be purely financial. It's generally enforceable. Only if you've come up with literally pulled a ridiculous figure out the air, will the courts look at it and say it's probably penal and not enforceable. So we mentioned the extension of time earlier. So the date for completion can be extended in certain circumstances. As I'm sure we're all aware, construction projects never run on time. There's always issues that push out that completion date. Under the JCT, they're called a relevant event. Under the NEC, I think it's compensation events, something like that. But they're all the same thing. No matter what you call them, they're the same thing. And it's events that happen that will allow the contractor to ask for more time to finish the project. It's things like employers' instructions, adverse weather, works by statutory undertakers, so electric companies, water boards, things like that. Any acts of government, so any changes to legislation, any new regulatory regimes that come in. Industrial action, as long as it's not limited to the contractor's own workforce. Obviously, the contractor can't get an extension of time if he's not paid his men and they've walked off site. And the general catch-all force majeure, which is traditionally was acts of God, flood, etc., etc. Obviously, pre-2020, no one envisaged COVID happening, so it wasn't included in the contracts. Now, all the contracts include pandemic events as acts of force majeure. So, the idea is if one of these events happens and it delays the work, the contractor applies to the employer for extension of time, and generally, providing that they've not been in default, they will get that completion date pushed back, which means that the date by which they have to pay LADs gets pushed back as well. So once we get to practical completion, whether on the original date or later, it's normally certified by the employer's agent or contract administrator or architect. Whoever has the contract will have a role, and it would say that that would determine which party signs off practical completion. You can have practical completion subject to a snagging list, so you don't have to have the works absolutely finished to the nth degree. Snagging lists can be anything from a few items to I've seen ring binders full of snagging items. There's no legal definition of what constitutes snagging, but it should really be just little bits and pieces that don't affect the employer's ability to use the property. Like painting, a bit of painting on a door or a loose window latch or things like that. Practical completion under the contracts triggers a number of events. So if any retention has been held on under the contract, so that's whereby each payment you make to the contractor during the course of the works, you hold a little bit back. The idea of that is that if the contractor goes bust, you've got a little pot of money there to help you deal with the problems. It's one of the most contentious things in construction at the moment, and is the reason for like 70–80% of subcontractors going bust is retentions. But again, that's a whole nother topic. So at PC, if the employer's been holding back any money, half of that gets released back to the contractor on PC. It brings an end to the contractor's right to occupy the site. Obviously, during the course of the works, the contractor has to occupy the site and is responsible for health and safety and controlling it. So he has to be able to manage who goes on and off that site. But at PC, that ownership and right to occupy the site goes back to the employer. The transfer of insurance risk also goes back to the employer. So during the course of the works, the contractor is probably going to be responsible for making sure that his works are insured as a result of any damage that's caused by them. At PC, that obligation stops, and the employer then takes over the insurance of the completed building. And it also starts the commencement of what's called the defects liability period. It's either 6 or 12 months, could be more, but generally it's 6 or 12 months, and we'll talk about that on the next slide. So yes, in defects. So after PC, the contractor is still on the hook for any defective work. So that's any snagging items included in the list of a list issued with the PC certificate. So if there's any snagging, they have to come back and fix that as soon as possible. There's also any defect notified in that defects liability period. So in that first 6 months or 12 months after PC, any problems, defective works that get the employer or the client, the owner notifies the contractor has to come back at his own cost and fix it. At the end of the defects liability period, so the end of that 6 months or that 12 months, providing all those defects have been rectified, the employer issues a notice, and that releases the balance of that retention. So that 50% of that retention that we were still holding at PC gets released at the end of the defects liability period. Again, the idea is that it's there. If the contractor doesn't want to come back and sort something out, you can use that money to get it rectified by somebody else. And then if you use that retention and then you can claim the balance back from the contractor. So that's it. And then at the end of that 12 months, 6 months or 12 months, the contractor's off the hook to come back and fix stuff at his own cost, but he will remain contractually liable under the contract for any defective works for 6 years or 12 years, depending on whether the contract's signed underhand or as a deed. But in those instances, you'd have to bring a claim. You'd have to go through the process of establishing that the contractor was liable for that, and rather than just getting them back to fix it, they have to be proved contractually liable to come back and fix those defects. We mentioned insurance, so just running through. So there's several types of insurance that contractors are required to take out. Now, the first one, contractors all risk, gets called car insurance. It can cause many confusion to trainee construction lawyers by asking about car insurance. But it just said here, it's a joint names policy covering damage to the works or site materials as a result of the contractor's negligence. It's for the full reinstatement of the works, plus if required, there's a percentage to cover professional fees. So if the architect needs to come back and redesign some bits and pieces as a result, that's covered by the insurance. Under the JCT, particularly, there are 3 options for that insurance. It's option A, option B, option C. Option A is in relating to new build works, and that's where the contractor takes out the insurance. Most instances for new build, that tends to be the case. but there is a risk of that just being everyone just defaulted to that as the normal, which is used to be fine. But as and when contractors start becoming more and more issues in terms of their solvency, it does cause a bit of a problem because clearly, if your contractor's insolvent, the insurance is no longer valid, and you're left with the works that are uninsured. Option B is again for new build works. In this instance, the employer insures. So that would get around that, obviously, that contractor insolvency issue because your client, you're insuring. If the contractor goes bust, the insurance is still there. It's some employers have it, some don't. It depends on the nature of your business. If you're not in the construction business or you're not a developer, you might not be able to get insurance on favourable terms. It may be better for the contractor to do it. So that's got to be balanced with the insolvency risk. And option C is where you're doing work in existing buildings, so it's refurbishments, things like that. Normally, in that instance, the employer insures simply because they will have building insurance covering the building anyway. So it's easier and for them to get an addition to that policy, and it avoids any double insurance issues where policies won't pay out because there's two policies covering covering the same works. And that, as you mentioned, the obligation to take that insurance on the contractor expires on practical completion, and that the insurance then reverts back to the employer, to the client. They also need to take out employer's liability cover, as any employer does. So it covers personal injury and damage to property arising out or caused by the carrying out of the works. There's also an option that they can, what's called non-negligent insurance. It's quite often called 651 insurance because that's the clause in JCT. It's optional, and it covers damage to property caused by the carrying out of the works, but not resulting from negligence. So the easiest example to think of is subsidence. The contractor's done everything absolutely right. He's not been negligent, but because of the nature of the site or the building, there happened to be subsidence that's caused damage to a neighbouring property. You normally see it when you're doing works in the centre of cities. I spent a lot of time working in London, and quite a lot of those, obviously, those sites are quite narrow, quite tight constraints. So you take this out. If you're doing a new build development in the middle of a field, a green bed, you're unlikely to need this because you're not at risk of causing damage to neighbouring properties by things like subsidence. And then finally, if they're carrying out design, they'll need to take out professional indemnity insurance. This also applies to designers, architects, and any subcontractors with design obligations. It covers against negligence in their performance of their professional duties. The level of cover, I often get, as a lawyer, I often get asked what level of cover they should have or whether it's sufficient. Really, my answer is not. It needs to cover enough to reflect the nature of their contribution to the work. So if you've got an architect designing obviously a multi-million-pound hospital, he needs to have sufficient PI. If you've got an M&E engineer that's designing a bit of electrical installations in a warehouse shed, doesn't need that much really, but it needs to be appropriate to what they're doing and their level of their involvement. It used to be that you get professional indemnity on each and every claim basis. So if you had 10 million PI, every claim against that policy would be, you would have 10 million available. The market has tightened up on the back of Grenfell and other recent events, and now we're much more likely to see it in the aggregate basis. So rather than having 10 million for each time you make a claim, there's 10 million, which is one pot, and every claim reduces that pot. Obviously, it's more of a risk for the client because you don't know how much pot of the pot is left when you bring a claim. But it's just the way the market's going now. Quite often, maybe what you would do is you would ask for, if you have to accept aggregate insurance, you would have to maybe ask for a higher level. So rather than 10, you'd ask for 15 million. Also, in professional indemnity insurance, you quite often see specific exclusions or limitations. So pollution, contamination, and asbestos is quite often restricted to an aggregate amount and lesser amount. There may be an exclusion for any cover of consequential losses, loss of profit, loss of business, that kind of thing. And more now you're seeing exclusions in relation to any fire safety issues on the back of Grenfell. Generally, that's fine. Although I have had a couple of times when I've had a fire engineering consultant trying to limit their indemnity on the basis of fire safety, which sort of kind of goes against the entire point of having them really. So that's the insurances, and that's basically a building contract. There's other things in there, but the other provisions deal with payments and instructions and variations and things. It's, we could spend all day going through the terms, but generally they're sort of the main key obligations of a building contractor. So under appointments, we've talked about architects, structural engineers. There's some others on there, so maybe acoustic consultant, quantity surveyor, employees agent, contract administrator. Depending on what the project is, there may be other ones. I've had an AV consultant. I've had, acoustic up there, but a swimming pool consultant. It just depends. It's anyone involved on the project, involved in either managing the contract or designing the works, essentially. And we would always advise that they are appointed under a quite a robust formal appointment, which sets out their scope of services and fees. We would advise they're executed as deeds, because then you have the benefit of the longer 12-year limitation period. They generally, appointments will require them to exercise a reasonable duty of skill and care. There's a requirement to maintain PI insurance. There'll be a copyright license in regard to any drawings and documents they prepare. There'll be a clause in there preventing them from using any prohibited materials, asbestos, that kind of thing. And there should be a requirement for them to provide collateral warranties in favour of the relevant parties. There may also include limitations on their liability, financial caps. So simply, like air liability is limited to 5 million. Generally, if it's in accordance with their PI cover, generally they're fine. Again, there may be exclusions for loss and profit or consequential loss. Things called net contribution clauses, which are a whole realm of fun, or might be exclusions limits in terms of their PI cover. So these things you've got to look at and just be aware of how that might affect your ability to claim any damage as a result of their negligence. So we mentioned collateral warranties. Now, collateral warranties are required due to the general rule of privity of contract, which is that someone who's not a party to a contract can't sue or be sued under that contract. And it creates a contractual relationship, allowing that third party to bring a claim. So if you're buying, as we mentioned earlier, if you're buying a property from a developer, and that developer has appointed a contractor and a professional team, and that professional team have made a mistake, you can't claim against them because you don't have a contractual relationship against that architect or that contractor. So what a collateral warranty does is it's effectively a promise. It's a promise from that architect or that contractor to you to say, we have complied with the terms of our appointment. To the extent we haven't, you can sue us. They're normally in favour of funders, mortgagees, purchasers, tenants, the other parties on there. It can be anybody who's going to possibly suffer a loss as a result of defects in the works. The key term of a collateral warranty is that they warrant that they will comply and continue to comply with the obligations under the appointment. Pretty much all the warranty needs to say, but through practice, we've started basically duplicating provisions of the appointment into the warranty. So again, it will set out a specific copyright license. It will set out their obligations in terms of not using prohibited materials. It will repeat their professional indemnity insurance obligations, and it will allow for an assignment of the warranty in the event that the property is then sold on, or somebody else comes in that wants to rely on the warranty. The key to a collateral warranty is that the party giving it owes no greater duty under the warranty than it would have owed to the beneficiary had the beneficiary named client under the appointment in place of the actual client, or words to that effect. Effectively, what we're saying is the warranty is collateral. So you're not getting anything extra by getting this warranty. All we're saying is we are assuming if you had appointed us in the first place, we owe you exactly the same duty and the same limits of liability and the same duty of care and as if you'd appointed us. And hence there's a same rights of defence clause in there. So the architect given the warranty can rely on the same defences as if you'd originally appointed them. Just to get to the point of you're not getting anything extra from it. They want that they will comply and continue to comply. Yeah, sorry, I've gone back, haven't I? Sorry. I'm very conscious of the time. Sorry, I'm going to canter through this now. So these are third-party rights and alternative to collateral warranties. They're introduced by the Contract Rights of Third Parties Act. They was always expressly excluded because no one can really understood them. The rights are the same as those are granted by a collateral warranty, but they're set out in a separate schedule. Um, and then rather than a warranty signed by all parties, you just grant a notice to say this person has the benefit of these rights. As I said, most people don't use it because it came in, no one understood it, and everyone just ignored it. Letters of reliance are alternative collateral warranties. They're used where consultants services are limited, normally to preparation of reports, surveys. It simply allows someone else to rely on that report and survey if it had been prepared for them originally. It's less than a full-blown warranty, but it's just like, we prepared this report for A, you B can rely on it. Latent defects warranties, these are things like your NHBC cover, your build safe, your Premier, etc. They are in fact insurance policies. Like most insurance, it's subject to a number of limitations, exclusions, etc. They last from 10 years from practical completion. The first 2 years, the developer is responsible for dealing with any issues. In years three to 10, the warranty provider, NHBC, will come in and deal with those problems. It doesn't cover everything a warranty covers. It only normally covers major damage to the structure and waterproof envelope. So things like mechanical, electrical fixtures are not covered. Doesn't cover design issues. The only advantage is that you don't have to go through the hassle of proving that you have a claim before you can claim under the policy. But the policies are very limited, and they don't give the protection that people think they do. And finally, very quickly, performance bonds. Normally get them from the contractor. The idea is that event of contractor default or insolvency, you can claim normally up to 10% of the contract sum. There are two types: guarantee on demand. On demand, you very rarely see in the UK market because it's simply the contractor's bust, I want the money, you give it to me. It very rarely exists in the UK market. So normally what we get is a guarantee bond, and the protection offered by these bonds is often misunderstood. Again, it's not a case of you submit the bond, the bondsman pays you. You actually have to go through the process of establishing that they're liable, you've got a claim, you probably have to go to court, win your court case, then not get paid out for whatever reason before you can go and claim on the bond. So they're useful, but they don't give the protection that people think they do. Apologies, that was a bit of a canter through the end there. I realised I was running over slightly, but I hope that all makes sense. Happy to answer any questions. Happy to have people email me afterwards with questions or clarifications. But that's a quick canter through. Okay. Well, if there are no questions, as I say, happy to. We'll share the slides that we shared with you. And I say happy to have any emails, anything you want to pick up, anything you want to know more information about, anything to clarify. Very happy to do so. But if not, I will leave you there, and thank you very much for listening.